Hello everyone and welcome to the another session of Industrial Relation Code 2020. In this class, we are going to study about the chapter number 5, that is the notice of the change. Under Industrial Dispute Act of 1947, the chapter number 2b talks about the notice of the change. That is, anything which is given into the Schedule 4, the matter in the Schedule 4, if any of the employer wants to make the changes in this matter, they are supposed to give a notice to the employee or whoever is getting affected within the 21 days of making such changes. The same provision is followed here under chapter 5. Only thing is here schedule is third. So the third schedule talks about the notice of the change. So section 40, any employer or the no employer who proposes to effect any change in the condition of the service applicable to any worker, respect of any matter specified in the third schedule, any person who is getting affected cannot make the changes, the employer cannot make the changes without giving an employees or the worker a notice in a prescribed manner within 21 days of these such changes. Now, such notice won't be required if any of the such changes are in pursuance of settlement or award. Means because of the settlement or the award, if the changes have been brought into the salaries and all or working condition, no notice required. It won't be applicable to all those workers who have been covered under fundamental and supplementary rules, civil service, classification control, civil service, temporary rules, revised rules, civilians in the defense service, classification control and all this. So any of the rules and regulations notified by the appropriate government as well as all these rules to whomever the workers it is applicable, no need of giving the notice of change. In any case of emergency situation, maybe because of the business fall, maybe because of the panic situation, if there is any kind of the emergency situation, if there is a change in the shift required, for that no notice is required. And if any of the changes is affected in accordance with the orders made by the appropriate government in pursuance of settlement or the award, no notice of change is required. Now, Section 41 says power of the appropriate government to exempt from this provision. So appropriate government is of the opinion that the provision of section number 14 has to be exempted for any of the establishment or class of the establishment may be in cause of serious corruption on the industry concerned or the public interest so required, it can exempt such establishment from the provisions of section number 40. So that is your chapter number 5, change in the notice. Moving to chapter number 6, voluntary reference of the dispute to arbitration. Under the Industrial Dispute Act of 1947, section number 10A talks about voluntary reference of the dispute to the arbitration. When employee and the employer are satisfied, they are having a differences, they are having a different dispute and they are mutually satisfied to refer the dispute to the third party who is an arbitrator, they can do it. The same provisions are here under chapter number 6. What does it say? Section number 42 says voluntary reference of dispute to arbitration, that whenever there is an industrial dispute existing apprehended, an employer and the employee, both of them agree to refer the dispute to the arbitration, they may refer the dispute to the arbitration and get it resolved. Now, when it get resolved, they come to an arbitration agreement. This arbitration agreement is to be signed by the number of the arbitrator who are acting as a third party. Now, in any case, there are more than one, or if there is a case when the arbitrators are actually coming to the position, they are equally divided by the opinion, then award would be given by an umpire, another person who is appointed by the appropriate government. He will come into the picture and he will decide what would be the actual thing to be followed on the agreement. The agreement, arbitration agreement, whichever comes out of as a result of this arbitration will be signed by both the parties, right, in a prescribed manner, and the copy of this arbitration agreement to be forwarded to appropriate government and conciliation officer. Why it has to be forwarded? Because in case they are not able to resolve voluntarily, then it is forwarded to the conciliation officer or your further settlement machinery by the appropriate government. So that is your section number 42, voluntary reference. Now, in any case, when we talk about referring the dispute to the arbitrator, so if an industrial dispute is referred to an arbitration, for the arbitration, the appropriate government is satisfied the person making the reference represents the majority of each party. So like we have employee and the employer. Employees are representing themselves and employers are representing themselves. So they are the representative. Any one or two people would be representing. In any case, if person is representing the majority of the employees within the organization, it is okay. If any case he is not satisfied, or appropriate government find that he is not representing, or there is something to be represented by the notification in a prescribed manner, the workers and the employer who are not the parties of the arbitration agreement but are concerned to the dispute shall be given an opportunity. So in case there is the requirement that even if the people are not the parties, they are not able to represent, but they are getting affected by the dispute, they would be allowed to represent themselves, provided where such industrial dispute is the industrial dispute other than the termination of individual worker by discharge, dismissed, retrenchment or otherwise, the worker shall be represented before the arbitrator. So if it is individual person, if it is the dispute related to individual person, then the individual person may be represented by either a negotiating union or a negotiating council, by negotiating union or a negotiating council. If there is already a negotiating union present, so negotiating union would be representing. If there is a negotiating council present, negotiating council would be presenting. If there is no negotiating union or negotiating council is present, then trade union would be there. And if there is no trade union, any such representatives of the worker chosen in the manner. So now this negotiating union and negotiating council is recognized. They are the recognized bodies of the trade union to enter into collective bargaining. Where such industrial dispute relate to termination of individual worker by discharge, dismissal, retrenchment or otherwise, the concerned worker shall be presented in person through a representative authorized to him. Right? So this is a representation. You should be aware how a person can be represented. Once the person arbitrator receives a dispute, he will investigate the dispute and submit the appropriate government the arbitration award being signed by all the arbitrators, or if there is only one single one, he will be signing. So award is to be submitted to the appropriate government. Now, appropriate government, whatever award is being submitted to the appropriate government, now whatever award is being submitted to the appropriate government, if the appropriate government feels, right, if the government feels that during this arbitration process, if there is a requirement of prohibiting the strike or lockout, it can prohibit that no strike or lockout would be carried out in this arbitration process. However, anything which is given under the Arbitration and Conciliation Act of 1996 will not apply to this section. That was your chapter number 6, small. 7. Chapter number 7, mechanism for resolution of industrial disputes. So here we are going to study what? We are going to study here conciliation officer or board of conciliation. Then we are going to study industrial tribunals and we are going to study national tribunals. Under the ID Act, under the Industrial Dispute Act of 1947, when we talk about mechanism of resolution of industrial dispute, we have labor code, we have industrial tribunal, we have national tribunal, and we have your conciliation officer, board of conciliation and so on. Here the labor court is being replaced, no more labor court is there. So we have industrial tribunal and we have national tribunals along with the conciliation officer. So the first one is conciliation officer. Who appoints the conciliation officer? So the appropriate government by the notification in the official gazette may appoint any officer of the government as an conciliation officer for mediating and promoting the settlement of the dispute. Now this conciliation officer may be permanent or the limited period of the time, ad hoc. Usually we take it as in permanent nature. and he can be specified for one area or for the number of the industries in the given area. Industrial tribunal, again the appropriate government by notification in the official gazette can constitute one or more industrial tribunal for adjudication of the industrial dispute. You can see here it is, officer is mediating, he is coming to a friendly solution or friendly agreement. However, industrial tribunal are adjudicating, they are giving the award. So there can be one or more industrial tribunals being appointed by the appropriate government. They would be exercising all the jurisdiction, all the powers or authorities which are assigned to them by the government. So now industrial tribunal can be constituted by either the state government or the central government, since we are saying it's an appropriate government. Now these tribunals whichever are constituted will consist of the two members. One is called as the judicial member, another one is called as administrative member. Whenever any kind of proceeding is happening, any of the tribunal is sitting, this tribunal may consist a single judicial member or single administrative member. So they can adjudicate into the matter singly, or they can adjudicate the matter together. Now when it comes to the adjudication process or a bench where judicial member is also there and your administrative member is also there, in that case judicial member will carry out the proceeding. For the qualification of judicial member, administrative member, it would be decided, the salary, the allowances, the terms of office, everything would be decided or constituted by the central government in accordance to the rules which are made under section 184 of the Finance Act of 2017. Provided any of the person who is being appointed as an administrative member of tribunal will not be below the rank of Joint Secretary Government of India or the equivalent rank in the central government or the state government. So this is the qualification required for an administrative member of tribunal. The term of office, the term of office for judicial member, administrative member, everything would be constituted by the state government. Wherever they are constituted by the state government, their salaries and allowances would be prescribed by state government. So case where central government is constituting, it would be decided by central government. A case where state government is constituting, it would be decided by the state government. And the procedure, suppose a procedure is going or a proceeding is going on and both judicial and the administrative members are sitting there. They are dealing with the cases or a benches is going on. What all matter they can deal into, this is important. So they deal with the matters like application and interpretation of standing order, what all rules and regulations should be formed, where it should be applicable, discharge, dismissal of workmen including restatement of grant of relief to the workmen dismissed, illegality or otherwise of a strike or lockout, retrenchment of workmen and closure of the establishment, trade union dismissed. So this is all the matter which has to be together collectively, consisting of the bench of judicial member and administrative member have to decide. Remaining cases other than this, they can be singly administered by judicial member or the administrator. They can go single, right? So whenever there is a bench, judicial member shall preside over the proceedings. Section 45. Finality of constitution of the tribunal. Notification, no notification which is given by the appropriate government for appointing judicial member and administrative member will be called upon into the question, and no act of proceeding would be taken up against this appointment. It means whatever appointment is done for judicial member or administrative member by the appropriate government, it is considered as the final, considered as in final. No question would be there, no proceeding would be or no act would be taken against it. 46. National Industrial Tribunal. So now this is a national, so the central government by notification in the official gazette can constitute one or more national tribunals. The central government will refer the matters which are of national importance or such nature that the national industrial establishment is situated in more than one state, likely to affect more people in more than one state, in that cases the central government would refer the matters to the National Industrial Tribunal. Again, this National Industrial Tribunal will consist of a judicial member and the administrative member. Any person who would not be qualified to be appointed as a judicial member until and unless he has been a judge of High Court. So below the rank of judge of High Court, no appointment as judicial officer. And no person would be appointed as an administrative member until unless he has been a secretary of Government of India or holding an equivalent rank in the central government or state government, having adequate experience of handling labor related matter. Whenever there is a bench, judicial member shall preside over National Industrial Tribunal proceedings. The procedure of selection of judicial member, administrative member, their salary allowances would be prescribed as per the central government. The central government, in order, if he feels that there should be the officers who would be supporting the judicial member or this judicial member or administrative member, the central government by any such number of the officers, if he thinks fit, can appoint them, and this is to be done in consultation with judicial member and your judicial member, that what all extra members have to be appointed. So that is your section number 46. Decisions of Tribunal and National Industrial Tribunal. Now, since there are two members in the tribunals, judicial member and administrative member, both the cases, whatever the decisions are coming up in both the cases, they have to be consensus of the member, means together they have to decide. So if the National Tribunal is having judicial member, administrative member and other such officers, they have to do it in the consensus, right? If the members of tribunal or National Industrial Tribunal differ in the opinion, in case they are differing in the opinion, they are not agreeing on one point, since there is only one, then the appropriate government will make a reference, right? They will make a reference and another judicial member. So what would happen? Let's say there is an judicial member, administrative member, they are not able to decide on certain dispute. So the judicial member of another tribunal or another industrial tribunal would be appointed as a third person and he will be making the decision. That is your 47. 48. Disqualification of members of tribunal and National Industrial Tribunal. So any person who is not independent person, who has attended at the age of 65 years, won't be qualified enough to be a member of tribunal or National Industrial Tribunal. So this is what? This is your disqualification if you become, if you are not independent person plus you have attended 65 years. Now independent person means who is not connected to the industrial dispute in any way. Procedure, powers of arbitrator, conciliation officer, tribunal, National Tribunal. All these people under this code have got civil code power under the code of civil code of civil procedure 1908, when they are dealing with the matters, when they are doing the proceeding, enforcing the attendance, compelling the production, issuing the commission. In respect of such matter prescribed, every inquiry or investigation of tribunal, National Tribunal shall be said to be judicial proceeding within meaning of section 193 228 of Indian Penal Code. Whenever appropriate government feels that there should be one or more person having extra knowledge or specific knowledge, can be appointed as an assessor or the expert to advise this tribunal or National Tribunal. Wherever the appropriate government feels fit, that they should be appointed, appropriate government can do that. Power of tribunal and National Tribunal to give appropriate relief in case of discharge or dismissal of worker. Now what happens in case employer has dismissed or discharged any worker because of any reason, terminated his employment in a way of discharge or dismissal. Now this employee or the aggrieved person has appealed to the tribunal, or the matter has been referred to the tribunal or in National Industrial Tribunal. The tribunals or the National Industrial Tribunal may rethink, and if they feel it is correct, may provide the relief to the worker by keeping aside the decision of the employer and give the award with the lesser punishment. Who? tribunal and national internal tribunal can do this. So tribunal or national industrial tribunal may be in interest of the justice grant such interim relief to the workers during the pendency of industrial dispute as the circumstances may be. Clear? 51. Transfer of pending cases is important. Now what happens here is, any of the on and from the date of commencement of this code. Now what? We have ID Act 1947. Any of the proceedings which are with the labor code, which are pending with industrial tribunal, which are with the national tribunal. Now this ID code is supposed to get repealed as soon as this code would be applicable. Industrial Dispute Act will get repealed as soon as this industrial relation code will be applicable. So what would happen to all these cases which are still pending with labor court, industrial tribunal and national tribunal? In that case, immediately before the commencement of this code, any of the matter or any of the proceeding pending with the labor court and the tribunal constituted under the Industrial Dispute Act shall be transferred to tribunal having corresponding jurisdiction. So into the same jurisdiction they would be just transferred to the tribunal, and in the national tribunal constituted under Industrial Dispute Act transferred to National Industrial Tribunal in the same jurisdiction. In cases of the under subsection 1 of tribunal or national tribunal shall be dealt with de novo or from the stage at which they were pending. So it won't start, it won't restart. It would be carried forward from the place where they were pending. So nothing would be gone, everything would be restarted and everything would be working as soon as the code becomes applicable. Adjustment of the services of presiding officer under repealed act. Now so we know labor court, industrial tribunal, national tribunal, they had one officers, presiding officer. What would happen to this presiding officer if this get repealed? In that case, the presiding officer of labor court, tribunal or national tribunal constituted under Industrial Dispute Act holding the offices immediately commencement of the code is qualified to be appointed or shall be qualified as a member, judicial member of tribunal or the judicial member of National Industrial Tribunal, and will remain into the continuous period of such time which is remaining for his office. So they won't lose the job. Conciliation and the adjudication dispute. Now how they are referred and so on. How this conciliation and the adjudication dispute are referred when they have to be, application has to be made. 53 says, when any of the industrial dispute is existing or apprehended, or a notice is given regarding this industrial dispute, the conciliation officer will hold the conciliation proceeding in such a manner which is being prescribed to him, but shall not hold any proceeding related to industrial dispute after 2 years from the date on which industrial dispute arose. So what is the time period given here? It is 2 years. The conciliation officer have to no, it's not talking about the reporting. It's saying that any of the matter on which the conciliation can deal is the 2 years. After that it won't be. Whenever the conciliation officer is dealing, the conciliation officer will try to bring the settlement of the dispute without any delay, investigate the dispute, the merits, demerit, and will try to come up to fair and amicable settlement. Wherever the settlement have arrived, they will submit a report to the appropriate government, and a memorandum of the settlement is to be signed by both the parties. In case no agreement have arrived, no settlement have arrived, the report for the failure in an electronic way have to be forwarded to the appropriate government, reporting, ascertaining the fact and circumstances related to dispute which they have undertaken, they have investigated, and then what all steps they have taken in order to bring the settlement. In spite of this, it got failure, right? So that is your section 53. Now, whatever report is being submitted to the concerned party or the appropriate government for this complete proceeding, this have to be done within 45 days of commencement of conciliation proceeding or within shorter period as may be fixed by the appropriate government. This 14, so we have studied under Industrial Dispute Act that a conciliation officer have to complete his proceeding or submit the report in 14 days. That clause is also there. We would be studying where it is. For now, just remember under this section, which section? 53 section. 53 section says that the conciliation officer within the 45 days will submit the report to the concerned party and the appropriate government within 45 days of the report of the proceeding. Now, provided the conciliation officer receives the notice under section 62, for section 62, the concerned party and the appropriate government have to get the report from 14 days. So, in relation to section 42, it is 14 days. However, this time period can be extended if both of the parties are agreeing. Now, any concerned party make an application in a prescribed to the tribunal in matter not being settled by conciliation officer within 90 days from the date on which the report under subsection 4 is received by concerned party. So what does this say? That if conciliation officer has failed, there was no output, settlement did not arrive, the report would be sent to the parties and to the appropriate government. Within 90 days of receiving such report, if the concerned party feel that they need to approach the tribunal, they can make a reference to the tribunal, but it has to be done within 90 days. For ID Act, it is 45 days given. Reference end-to-end functions of National Industrial Tribunal. So what all matters and who is going to refer the matter to the National Industrial Tribunal? So central government will refer all the matter which of national importance to the National Industrial Tribunal. The National Industrial Tribunal will deal or investigate into the matter proceeding expediently into the given prescribed period of the time and will send a report to the central government, rather submitting the award to the central government in the prescribed time period. 55. Form and award its communication and commencement. Whatever the award comes out of arbitration, it comes out of tribunal output or national tribunal, in what form the award has to be. A award which is the result of a bench which is consisting of judicial member and administrative member, or a single judicial member or a single administrative member, or any of the award which is coming out of national tribunal. First and foremost thing, they need to be in writing, signed electronically or otherwise by both the members, and if it is either by single person judicial member, signed by judicial member, and if it is the single person administrative member, signed by administrative member. So award has to be in writing. Every arbitration award, every tribunal or National Industrial Tribunal will be communicated to both the parties involved and the appropriate government from the date of its communication under subsection 2, provided appropriate government is of opinion in any case where the award has been given in relation to which it is a party. If the central government is of any opinion where the award has been given to a National Industrial Tribunal on the public interest is, so now this is like as an tribunal or as an arbitrator or as an National Industrial Tribunal, I submitted the report to the appropriate government or to the central government. If either of them, either the appropriate government, either the central government feels that on the grounds of national economy or the social justice on public interest, if this enforcement of this award will affect it, they may stop or they may declare that the award will not come into the force on the expiry of the period of 30 days. So usually any award, when the report get forwarded to the appropriate government, after the expiry of 30 days, it is enforced automatically. However, if the government feels no, we don't want to do it, it may give the order and it won't come into the enforcement. Now, when this is being made, a report is being submitted to the appropriate government, if the appropriate government, as the case may be it is central government or the state government, if they want to modify or make any of the changes, it will first give an opportunity and then modify it. The later one, so modification would be made and the copy would be forwarded before the legislature in front of the state if it is the state government, and before the parliament if it is the central government. And this modified award will come into or will be enforceable on the expiry of 15 days from which it was laid down before the parliament or the legislature. Right? The award shall become enforceable on expiry of period of 90 days in case it is being not modified. If it is modified after the expiry of 15 days when it was laid down in front of the parliament, and if it is not, 90 days. Clear? Now understand this. How does this work? So if an appropriate government receives an report, appropriate government have a modification or they want to make a modification, they will make a modification and present it before the parliament or the state legislature. The date on which it was represented, after that expiry of 15 days, so if suppose it was presented on to the parliament on 1st of Jan, so after 15th Jan the award will become enforceable. And in case where no such order of modification is being made, the award will become enforceable after the period of 90 days referred in subsection 4. So this 90 days, right? So whenever any of the modifications are not made. Clear? Whenever the award comes into the operation, it would be into the operation as per the date mentioned into the award, and if no such date is mentioned, if there is no such date mentioned, then as soon as it is being passed, it becomes enforceable. Section 56, payment of full wages to the worker pending proceeding in higher court. Now what is this? Labor court, industrial tribunal, your industrial tribunal, national tribunal, they all tried to come to a settlement. But anyhow, if the tribunal or the national tribunal, they feel or the any worker or the employer, they want to appeal it to the higher court, it can go to the higher court, either Supreme Court or the High Court, and this can be made by tribunal or National Industrial Tribunal. They make a reference to the higher court. When the proceeding is going on in High Court or the Supreme Court, the worker or the employee who is affected by this proceeding will get full wages, inclusive of maintenance allowance admissible to him. Any rule if worker had not been employed until unless there is any kind of the rule or compensation provided, adequate remuneration provided, otherwise the worker is supposed to get the full wages. Person on whom the settlement would be binding. So when the settlement arises, who would be the people or the parties who have to follow this settlement or the award? They are binded to it. So in case of the settlement, the agreement between which the worker or the employer, between whom the settlement have come, and in course of conciliation, they are the both parties on which it would be binding. In case of arbitration award, it would be binding between the people whom the agreement have arisen. In case of arbitration award or tribunal or national tribunal which has become enforceable shall be binding on all the parties, those who were in the industrial tribunal, all the parties, those who appeared in the proceeding, either they are related to the dispute or not, but they came there for recording the opinion, they summoned themselves, they would be binding. Where a party is an employer, his higher successor assigned in respect to establishment. So if the employer is there, his legal representative is there, so in that case all those on them it would be binding. In case of the worker, all the persons who were employed in the establishment and part of establishment to which the dispute relates, to whomever the dispute was related to, for all of them the settlement award would be binding. Clear? So that is the section number 57. Now, period of operations of the settlement and award. to what period, to what time, till what time the settlement would be in operation. Any of the settlement which is coming out of the conciliation proceeding, if there is a date, whatever time period is mentioned, for say 1 year, the settlement would be applicable for 1 year, in operation 1 year. If no such date is mentioned in the memorandum, it would be in operation at least for 6 months. And it will continue to be in operation after the 6 months until and unless any of the party who want to terminate, or who are having an intention to terminate this agreement, make a notice make a notice of 2 months. They have to make a notice. 60 days basically. 2 months is under Industrial Dispute Act. So let's say employee and employer, they came to an agreement through the conciliation, and this settlement is applicable, or there is no date till what period it would be in operation. So 6 months is the minimum time for which it would be in application. So now employee and employer are like, no, 6 months is done, now we are free from the settlement. No, you are not free until and unless either of the party who is looking forward to break that agreement make a notification in writing before within 60 days. The notification would be of 60 days. It will notify that we are now terminating this agreement. After the expiry of this 60 days only, that particular settlement or agreement would be terminated. In case of the award, arbitration award tribunal or national tribunal, minimum time period is 1 year, which can be extended to the total period of the 3 years, not more than that. Now, this is the operation period for the settlement and the award, which is very, very important. In case if the appropriate government feel that the term period for any award has to be increased, it can be increased. If they feel any of the award period have to be decreased or shortened, it can decrease. Recovery of the money due from the employer. So in case any of the money is due to the worker from the employer for the settlement of the award, right, under the chapter number 9 and 10th, we will be studying them. Any kind of the money which is due, the recovery can be made by making an application to the appropriate government. So now who would be making an recovery, or who would be making an application? So in case of the death of the worker, his assignee, hire, or whoever is the legal representative will make an application to the appropriate government. The appropriate government will issue a certificate to an collector mentioning the amount which is to be recovered. The collector will collect that or recover that amount as an arrear on the land revenue, provided any of such application which is being made to the appropriate government has to be made within 1 year from the date on which the money becomes payable or due to the worker from the employer. The worker is entitled to receive from employer any money or benefit which is capable of being computed in the terms of money, and if the question arises whether this benefit is to be given or not, how? So it would be as per the rules, right? So if there is a question whether this money is payable or not, it would be decided as per the rules, and this is done by tribunals behalf. The appropriate government makes an application or refers it within the period not exceeding the 3 months. So what is the time period to decide? It is 3 months. Clear? Commencement and conclusion of the proceeding. This is important. When any conciliation proceeding or an award or any of the arbitration proceeding or any of the adjudication proceeding is said to be concluded. So if it is a conciliation proceeding, the conciliation proceeding is deemed to have commenced on the date on which the first meeting is held. So when does it start? The day on the first meeting was held, and or on the date when the conciliation officer related to that industrial dispute receives a notice of strike or lockout. After that, whenever the first meeting. So what happens actually when employee and employer are having a dispute? They try to resolve it collectively, but if they are not able to do it, they refer it to the conciliation, or they go on strike. But when they go to the strike or lockout, there is a cooling off period of 14 days. That you, this 14 days, during this 14 days, the matter is referred to conciliation officer. So as soon as the notice of the strike or the lockout arises or comes, whenever it comes to the conciliation officer, after that the first meeting, from that first meeting it is said that the proceeding for conciliation have started, commenced. And when it ended, when the settlement is arrived, when a memorandum of settlement is signed by the parties. So first thing is when they sign the both of the parties sign the settlement, that is the end. Where no settlement is arrived and failure of conciliation is recorded by the conciliation officer, it failed. When a reference is made to the National Industrial Tribunal under this code during the pendency of conciliation proceeding, a reference is made, it was not resolved, so reference was made. And if proceeding, so this is in the case of the conciliation, all the conciliation proceeding is said to be end here, or they are considered to be concluded in these three cases. Wherever the proceeding is with the arbitrator, it shall be deemed to be commenced on the date of filling of application or appeal, or on the date of reference of the dispute. So I may make an application, right, as an worker, application can be made, and the date the application has been made or any of the dispute has been referred by the appropriate government to arbitrator or industrial tribunal or national tribunal. From that place, from that date, the commencement of proceeding starts, and it is concluded on the date when the award becomes enforceable. Until unless it becomes enforceable, it is not concluded. Certain matters to be kept confidential. So whatever proceeding conciliation officer, industrial tribunal, industrial tribunal, arbitrator, they go and they make a report, the award, whatever information is collected during this process is considered to be confidential, and this information cannot be made available to any of the person otherwise than required, right? So this is very, very confidential. This cannot be disclosed without the consent in writing of Secretary of Trade Union or a person, firm of the company. So their case, whatever case may be, it has to got you can say writing consent, then only it can be disclosed. Chapter number 8, strikes and lockout, very, very important chapter. Now, if employee and employer are having a dispute and they try to resolve it through the collective bargaining, it was not resolved, arbitration, it was not resolved, so in that case they can move to strikes or lockout. Now there is certain prohibition for strikes and lockout which are given under section 62. 62 clause 1 prohibition of the strikes for the employees, and 62.2 clause 2 is prohibition of lockout. Under the Industrial Dispute Act, this is given under section number 22, which is applicable to public sector, public utility services. 23, which is applicable to both public utility services, non-public utility services. That is under Industrial Dispute Act. Here we are going to study it in the section number 62. Now what does this says? Any of the employee or the group or the trade union, they want to go on the strike. So no person employed in any of the industrial establishment shall go on strike in breach of contract without giving an employer a notice of the strike hereinafter provided within 60 days. Earlier under Industrial Dispute Act, it is without giving the notice within 6 weeks. Here it has changed to 60 days. Before means before you go on strike. So whenever you are striking, within 60 days of this striking, whenever you strike, within 60 days of this striking, you are supposed to give a notice. And the date on which you are giving a notice to the employer, within this 14 days of notice, you cannot go on strike. So within 60 days before the striking, the notice is to be given, and the date on which the notice is being given, from that date, within 14 days, you are not allowed to go on strike. Before the expiry of the date of strike specified in the notice, if you are specifying certain date, you have to follow that date. Before the specified date, you cannot go on the strike. If any of the proceeding is pending with the conciliation proceeding, conciliation officer, during that pendency and 7 days after the proceeding, any of the pendency of proceeding before tribunal, National Industrial Tribunal, and 60 days after that proceeding, during the arbitration proceeding, whenever arbitration proceeding is going on, and the 60 days after the conclusion of such arbitration proceeding. Finally, any of the settlement or award is in operation, if they are in operation in respect to the matter related to which the dispute is going on, no strike would be allowed. These all conditions are similar for lockout. The employer have to follow the same conditions. Now, suppose there is an industry where already the strike is going on, or already there is a lockout. Strike is going on and lockout already is there. So, if there is an already existence of a strike, in that case, employer don't have to give the notice for lockout, right? So, employer shall send an intimation of such lockout or strike on the day on which it was declared to such authority. So, as an employee, I am on the strike. Do employer need to give a notice for lockout since strike is going on? No. And otherwise, if there is already lockout being done by the employer, do employees need to give a notice for the strike? No. The only thing they have to do is the employer will send a notice of this lockout or strike that is happening in their industry to the authority which is being specified by the appropriate government, either by the general or particular area. So it is the responsibility of employer to make sure the authority knows, right? Notice of lockout shall be given in a prescribed manner. Notice of the strike shall be given in prescribed manner. Whenever a strike is being notified to the employer, whenever the employer receives that notice, within 5 days of receiving such notice, the employer will inform the appropriate government or the authority as may be prescribed or the conciliation officer regarding that strike, so that the conciliation proceeding can be carried out. Illegal strikes and lockout. When the strike is said to be illegal, if it is contravening section 62 and if it is contravening the subsection of section 42, right? We have already studied the section 42. In all these cases, it is considered to be illegal strikes and lockout. And in pursuance of strike or lockout in industrial dispute has already commenced as in existence in the time of filling of application. Now, what is this? That let's say if there is a already proceedings or there is already a strike, not proceeding, already a strike going on in an industry, and while this strike was going on or while the lockout was into operation, the matter was given or matter was referred to tribunals or arbitrator. Though the strike or lockout was in process, during this process only it was referred for the adjudication or arbitration, this strike or lockout won't be considered as illegal. They are not illegal. It will continue to happen. Any of the lockout which is being done in consequence of illegal strike, that is considered to be legal. And any of the strike declared in consequence of illegal lockout is the legal strike. 64. Financial aid not to be provided. So no person knowingly will spend any of the or give the financial aid for illegal strikes or lockout. That was a chapter number 8. Now moving to 9th. Layoff, retrenchment and closure important. Now we have chapter number 9 and 10. 9 is simple provision, normal provision for layoff, retrenchment and closure, and your chapter number 10 is your special provisions. Okay? So layoff, retrenchment and closure. Where this particular chapter would be applicable, section 67 to 69. This sections where this would be applicable. So this section 67 to 69 talks about layoff, retrenchment compensation, layoff compensation. So where they would be applicable. First, section 67 to 69 both inclusive shall not apply to industrial establishment to which chapter X. So chapter X is your special provision. Wherever the chapter X special provision is applicable, this provision won't be applicable. Clear? And to this, in the establishment where there are less than 50 workers on an average per day working have been employed, not applicable. And those industrial establishments which are of seasonal character won't be applicable. The same definition, the same thing is given under Industrial Dispute Act under chapter number 5B. When we talk about 5B, the same provisions are there. So it won't be applicable in these three cases. Here, for the meaning of establishment, if the question arises whether the establishment is of seasonal character or not, the appropriate government would be deciding. For section 67, 68, 67, 68, 69, where this particular provisions are applicable, for this establishment would be considered what? It would be factory, mine and plantation. So the factory defined under the Factories Act, mine defined under the Mines Act and plantation defined under the Plantation Act, on those industrial establishment only the provisions would be applicable. What is the definition of continuous period, continuous service? Same. It is same as defined in earlier laws. Any of the person who is working above the ground is supposed to work for 240 days. If it is 1 year, below the ground 190 days. If it is below the ground, above the ground 240, below the ground 190 for 1 year, above the ground 120 days if it is 6 months, and below the ground 95 days if it is 6 months, right? So this is same. Plus, while calculating this continuous service, you would be considering the time when the person was laid off, when the person was on full wages, was on leave with the wages, the person was absent due to temporary disablement, the female was on maternity leave as per the Maternity Benefit Act, right? So these all provisions are same as defined in our Industrial Dispute Act. The only thing that has been differing here is the section and the chapter. Otherwise, everything is same. Clear? Next, right of workers laid off for the compensation. Again, the same provision. Any of the person on whom the chapter number 9th applies means establishment which is employing more than 50 and less than 100 employee, when they are being laid off, they have the right to receive the compensation. So any worker other than the badali worker or a casual worker whose name is brown in the muster roll, who has completed 1 year of the continuous service, if employer is laying him off, the person being laid off will get an compensation which is equal to the 50% of total basic wages and the dearness allowance. So what it is? 50% of D basic plus dearness allowance. But during which he is being laid off except for such weekly holidays. So weekly holidays won't be considered as the laid off, right? So payable to him, had he not been so laid off, the worker so laid off for more than maximum that person can be laid off is 45 days. After that, no compensation is given. Same as that of ID Act. Provided in any case, it shall be lawful for an employer in any case falling within foregoing provision to retrench the worker according to section 70 after the expiry of 45. So maximum is 45 days. After 45 days, the person can be retrenched by the employer, right? Because maximum 45 days a person can be laid off. After that, he would be retrenched and he would be getting the compensation. Now here the definition for the badli worker is a worker who is employed in an industrial establishment in place of another worker whose name is given in the muster roll of the establishment, right? But shall cease to be regarded if he has completed 1 year of continuous service in the establishment. A badli worker, he is the one who is appointed in the place of worker. Worker is absent, in his place he is working. He will be called the badli worker until and unless he completes 1 year. The moment he completes 1 year continuous service, he is no more badli worker. Duty of the employer to maintain the muster rolls of the worker. So it is the responsibility of the employer to make sure that muster roll is there, number of working hours, present people, it should be their responsibility. workers are not entitled for the compensation. When a person being laid off is not entitled, he is being laid off, and if an employer gives him an alternative employment within the radius of 8 kilometer from the original establishment, from the place where he was working, and this alternative employment is not making any difference in his skills, his previous experience, if this alternative employment is refused by the employee, he won't be getting the compensation. And if he does not present himself for work at establishment at appointment time during normal working hour at least for one day, he is not presenting, he is working normally in an organization, and any day if he is not presenting himself by notice, it means he is being laid off. It means he won't be getting then layoff compensation. If such laying off is through because of the strike which is affecting the production on the part of the workers, or it is an illegal strike, the person won't be getting the layoff compensation. So now understand this. Section 67, 68, 69. These three sections are applicable where? To the establishment, industrial establishment, factories, mines, plantation, and the complete chapter is applicable where? Wherever there are more than 50 employees and less than 100. Coming to section 70, retrenchment. No worker in industry who has completed a 1 year of continuous service, the employer won't be retrenching him without giving him 1 month notice, indicating the reasons why he is being retrenched, and he would be paid a compensation. The compensation is 15 days average pay or average pays of such days as may be notified by the appropriate government for every completed year of continuous service or thereof in part of 6 months extra, right? So that is 15 days average. The notice has to be given in a prescribed format given by the appropriate government, or such authority may be prescribed by the appropriate government. Procedure for retrench. Who would be retrenched? In any of the industrial establishment who is a citizen of India and he is being retrenched belonging to certain category of the workers, in the absence of any agreement, whatever agreement, he is being, suppose there is no agreement of the employment, in that case a person would be retrenched as a last person being employed. So if there are A, B, C, he joined on 1st January, B joined on 1st Feb, C joined on 1st March. So the last one person would be retrenched first. Section 72, re-employment. This is given under section number 25H of Industrial Dispute Act. If again any of the openings for which the person in a category for which the person was retrenched, if there is a chances of re-employment, he would be given an opportunity to re-employ himself. So where any worker who is retrenched and the employer proposes to take the employment of any person within one such year, right, within such 1 year, he is again, so he can be given an opportunity for re-employment. Compensation of the workers in the transfer. So it is same whenever the management transfers, whenever the company ownership transfer, the compensation would be given to the person who is getting affected by this transfer, and it is 15 days of average pay, but a person should have completed at least 1 year of continuous service. However, this transfer compensation is not to be given if the services of the person being transferred is not affected, if the place where he is being transferred, the terms and condition in which he would be working are not less favorable or equal to what he was doing in the last, and if the new employer or the new owner is legally liable to pay the retrenchment compensation if he is removing anyone. In these three cases, the transfer compensation is not to be paid. 74 says 60 days notice to be given in the intention of closing down. This is the notice which is to be provided by an employer if he is planning to close close his complete organization or establishment. He would give a 16 days notice in writing, and the parties, or you can say the trade union or the employees, giving an intention, writing an intention why he is closing down to the appropriate government, clearly stating the reasons. However, this section of giving the notice of closure does not apply to the place or the industrial establishment where there are less than 50 workers employed, or it is the construction of building, bridges, roads and canal. So here it won't be applicable. In case if there is any exceptional cases, circumstances as an accident or undertaking or death or employer or extraordinary situations like natural calamity, in that case it can direct the establishment, the government can give the exemption for this particular orders. Compensation of the worker in closing down, it is same, 15 days of the average pay. In case such closure is because of unavoidable circumstances, instead of this 15 days average pay, the employer can give average 3 months pay only in avoidable circumstances. And which all the cases are not the unavoidable circumstances? Financial difficulty is not unavoidable, accumulation of undisposed is not unavoidable, expiry of the period or lease not unavoidable, and mining of rate, if the establishment is mining, exhaustion of the minerals is not unavoidable, and it shall not be deemed to be closed down on the unavoidable circumstances beyond the control. This all won't be considered. He is supposed to give the compensation. In case it is the mines, because of exhaustion of the mines, the employer is supposed to give the compensation. The mine establishment is not supposed to give the compensation if he is providing an employment between the radius of 20 kilometer into the another mine where his work does not get interrupted, an alternative employment, and in case the new employer is having liable to pay the retrenchment compensation. Effects of the law inconsistent with this chapter. So now you can just go through it by yourself. That is not that difficult. Moving to next chapter, special provisions to lay off, retrenchment, closure in certain establishment. This chapter number 10th is applicable to those establishment. Now this chapter 10th, earlier we did where there are less than 100. Now this is 100 or more, provided they are not seasonal establishment, not intermediate. So if not less than 300 workers, right? So this provision of this chapter shall apply to industrial establishment not being establishment of seasonal character, on which the work is performed only intermediately and which not less than 300 workers. So now under the chapter number 5B, it was 100 or more. Here it is, the number has increased to 300 or more. So now 300 or more, wherever it is applicable, the chapter would be applied. Give me a second. Okay, so okay, fine. So it has extended from 100 to 300, right? That is what you need to remember. Now what is the provision? Again, the industrial establishment, factory, mine and plantation, appropriate government would be deciding. First and foremost is there is a prohibition of layoff. If you are having 300 or more people working in your organization, you cannot lay off them easily. You are prohibited. You are prohibited to not to lay off until unless you are taking a prior permission from appropriate government with the reason of shortage of power, natural calamity, flood, excess of inflammable gas, explosive. You have to specify the reason and ask for the permission. The application is supposed to be made electronically or otherwise, stating the reasons. Simultaneously, the application have to be served to the workers also, that why the layoff being is done. Now, this application has to be sent within 30 days. How many days? 30 days of commencement of layoff to the appropriate government asking for the permission. Now appropriate government, it will look into the application and giving an reasonable opportunity to the employer and workers being heard, it can allow or refuse, grant or refuse the permission of the layoff. Whatever the order is communicated to the employer regarding this refusal or granting, this communication has to be in application at least for 1 year. Till 1 year you cannot lay off if you are refused to or you are not granted the permission. And in case the government has not communicated anything, 30 days have expired and they have not communicated, you made an application. So in that case, after the expiry of said 60 days, after the expiry of 60 days, if the government has not communicated whether refused or you can say refused or rejected or you're granted, after the expiry of this 60 days, the automatic or it is said to be deemed to be approval, right? Deemed to be approval. Clear? So that is your layoff. Now, in any case, if such order of refusing or granting the permission of layoff either by the employer or the worker, they want to refer for higher tribunals, it can be referred, and such reference have to be made from 30 days from the tribunal, right? And such reference, provided the reference has been within 30 days from the made to the tribunal under subsection, it shall pass an award. So within 30 days the tribunal will give the award on the matter which is being referred to it by the appropriate government on the motion of either employer or the worker. Condition for precedence of retrenchment: any person who has completed 1 year is supposed to get 3 months notice plus prior permission from the appropriate government, an application making the clear reasons, stating the reasons why they want to retrench. Copy of such application has to be served simultaneously to the worker. A permission to the government, from the government, an application, you can say notice to the or application to the workers. The government may go through it, inquire into it and refuse or grant. Whenever it is refusing or granting, the order would be applicable for 1 year. In case no communication is being made after the expiry of 60 days, it is deemed to be approved, right? Now whatever the appropriate government is making a decision, it would be final for the retrenchment. Section 80, proceeding for closing down any industrial establishment. 90 days, any employer who wants to close or intention of having closure of the establishment, he is supposed to take a prior permission plus prior permission of 90 days notice and prior permission with the intention why he is closing. Simultaneously it should be given an notice to the representative of worker, but such notice is not required in case of construction, bridges and road. Whenever notice is being made, appropriate government may grant or give such permission. Such permission or the refusal would be applicable for 1 year. Now in case it has been made and application has been made, permission has been asked and no answer has been communicated by the appropriate government, after the expiry of this 60 days, it would be deemed approval, right? 81. Duty of the employer to maintain the register muster roll related to all this chapter. Certain provision of chapter 9th. So 9th, for 9th chapter, 66, 71, 72, 73, 76. This is related to compensation of layoff, retrenchment, closure and transfer. In chapter 10th also, if any of the person is being laid off, he is supposed to get the compensation as given in 66, 60, 70, 71, 72 and 70. So those provisions are applicable here. 11th, important, newly added, worker reskilling fund. 83 says, any of the appropriate government by the notification in the official gazette will set up a fund called as the worker reskilling fund. The Fund will be having a contribution from the employer of industrial establishment, an amount equal to 15 days of the last drawn by the worker immediately before the retrenchment. So this is specifically for the retrenched people. Any person who is being retrenched, this fund will have a contribution from the employer, an amount equal to 15 days of his last drawn salary, or any such amount which is being notified by the central government, and any other contribution which is coming from any other sources as decided by appropriate government. This amount or this fund would be utilized by crediting 15 days last drawn salary by the worker who is retrenched within 14 days of his retrenchment. Within the 14 days of his retrenchment, the amount has to be credited. So that is worker reskilling fund. So it has 15 days average salary of the worker who is being retrenched, and within 45 days it has to be credited. Clear? Moving to next. Unfair labor practices, chapter number 12. Section 84 says prohibition of unfair labor practices. No employer or the trade union is allowed to practice any kind of unfair labor practices. They are not going to engage themselves into the matter or the unfair labor practices given into the second schedule. Offences and penalties. Now this is something which you can go through by yourself because they are going not to be that they are not going to be asked in exam. Just go through it by yourself. Moving to the 14th chapter, miscellaneous. Now this is important. Section 90. Condition of service etc. to remain unchanged under certain circumstances during the pendency of proceeding. Now let's say some proceeding is going on, either conciliation, either your tribunal or arbitrator related to industrial dispute. The proceeding is going on, and the matter related to which the industrial dispute is going on, can employer make a changes in his conditions or the services applicable related to worker? No, he cannot make any changes. He cannot make any changes related to the dispute for any of such misconduct conducted by that person, right? Until and unless there is a permission in writing from the authority. So there cannot be changes in the condition of the services when the proceeding is going on. Now, that was your related to service and condition. Can be changes made for the standing orders? Again, no. Any matter for which the dispute is going on which the standing orders or the condition of services are applicable, no changes can be made in the related to the standing order when the proceeding is going on. Also provided, no such worker shall be discharged, dismissed unless he is being paid a wage of 1 month and application has been made. So in any case, the changes condition cannot be changed, and if it requires, in any case it required to dismiss him, discharge him, so the application has to be given and his wages of 1 month has to be paid to the person. Another thing which cannot be changed is any of the actions cannot be taken against the protected workman related to the industrial proceeding going on during the commencement of the proceeding, and the altering of the conditions are completely prohibited immediately before the commencement of the proceeding. He cannot be discharged or punished whether by dismissal or other way. Who? Protected worker. Anything which happens, anything if has to be done, it has to be in writing. Clear? In case of the protected workman. Who is the protected workman? So for every registered trade union, 1% of the total workmen belonging to that industry, 1% or minimum of 5 workmen, maximum 100 workmen of this trade union are declared as a protected workmen by an employer, right? So that is your protected workmen. They are recognized as the protected workmen. Where an employer makes an application to the conciliation officer, arbitrator, tribunal or industrial tribunal For the approval of action taken by him, authority consents without delay here such application pass within the period of 3 months. So let's say proceeding is going on. So if conciliation proceeding is going on, employer wants to make the changes, he would make an application to conciliation officer that we are changing. And in case it is tribunal, the employer will make an application to the tribunal. So this conciliation and tribunal will within 3 months answer to such application. Now that was during the proceedings and arbitration. Now special provisions for adjudication as to whether condition of surface etc. change during the proceeding, pendency of proceeding. Again, if any of the contravention is taking place for section 90, means if employer dismissed, discharged, they have dismissed, discharged a person during the section 92 of proceeding which is completely prohibited, you cannot take such action. In that case, aggrieved person will make an application to the conciliation officer if it is conciliation proceeding, tribunal if it is industrial tribunal, national tribunal if it is industrial national tribunal. Complaint would be filed and the action would be taken up. Right? Power to transfer the certain proceeding. Appropriate government has the power to transfer the proceedings to the tribunals if required. Right? It will be transferred. So one tribunal to another tribunal, it can transfer, and it will start from where it was continue from the where it was ended. Similarly, the central government can transfer the proceeding to national tribunal from one to another. Right, with the reasons empower any of the tribunal to deal into the matter. Now this is what you can go through it by yourself. Representation of the parties is important. Now any worker who is a party of the dispute, he is a party of dispute, by whom he can be represented in this dispute. Any member of executive or office bearer or registered trade union, any member of executive or other office bearers of federation of trade unions, any worker who is not a member of trade union, any member of executive. So this is for the case who is a member of trade union. In case he is not the member of the trade union, by the member of executive or office bearers connected to the trade union of the industry. In whichever industry is working, there must be a trade union. Though he may not be the part of the trade union, he can be represented by it. And the employer would be represented by officer of association of employer, officer of federation of association. Where the employer is not the part of association, the association which belong to industry may be the representation. Now, no party to the dispute shall be entitled to represent by legal practitioner in any of the conciliation proceeding tribunal, national tribunal. So no legal practitioner. Notwithstanding, any proceeding before tribunal or national tribunal, a party to dispute may be represented by legal practitioner with the consent of other parties to the proceeding with a leave of the tribunal. So now first thing is, you cannot represent, you shall not be allowed to represent through the legal practitioner. However, if you have permission, other party gives you the consent, you can present it by the legal practitioner. Removal of doubts in interpretation of the award and settlement. If suppose there is an award, if there is a certain settlement and both of the parties, either one of the parties is not able to interpret it, or the employer have not interpreted it correctly, so in that case, appropriate government will be removing the doubts in related to settlement, industrial tribunal or national tribunal, after they are being given an opportunity to be heard, and they will decide the question. Power to make the rules is with the appropriate government. Power to amend the schedule. Central government will or can amend the first schedule, second schedule and third schedule. Right? So who can amend? Central government. So now this is repeal and savings, that after this particular code come into the existence, these three laws will be repealed. Clear? The three schedules 1, 2 and 3. First is your matter related to standing order, second is your unfair, and the third one is your notice. What all matters are related to notice of change. So here we complete the industrial relation code. Any doubts you can always ask me.